Welcome to this explainer. Today, we're unpacking the literal DNA of democracy. We're going to break down the macro to micro framework of constitutional power, individual rights, and the frankly fascinating tension between the two. You know, if you've ever found yourself wondering how a massive, incredibly complex nation is actually held together on a bedrock of legal principles, and how those rules protect, or sometimes don't protect, everyday citizens, well, you are exactly in the right place. Let's get right into it.
Okay, let's kick this off with a genuinely beautiful metaphor. Former Chief Justice of India, D.Y. Chandrachud, compared the basic structure of the Constitution to the North Star. He called it an unfailing guide which shows the direction when the path appears convoluted. I absolutely love this because it anchors the whole concept we're exploring today. A constitution, you see, isn't just some dry, boring list of rules. It actually has a living spirit, a foundational framework that holds up the entire weight of the text.
So here is our roadmap for today's explainer. 1. The Constitution's basic structure. 2. The 6 fundamental rights. 3. Suspending the rules. 4. Defining the right to equality. And finally, number 5. Exceptions to equality rules.
All right. Section 1. The Constitution's basic structure. The North Star of democracy. First things first, we really have to understand the original character of the document. We're talking about the parts that simply cannot be altered or destroyed without the whole system basically losing its identity. Now, looking at these original handwritten notes is just so cool because you see these massive, world-altering concepts captured so simply. The foundational aspects listed here, they represent the absolute supremacy of the Constitution itself. It's the ultimate realization that any democratic state needs an untouchable core. Why? To prevent any single governing body from just rewriting the rules of the game to suit their own temporary needs.
Let's look a bit closer at what those core aspects actually are. We're talking about the sovereignty of India, the ideal of a welfare state, the republican and parliamentary system, federalism, secularism, the rule of law, judicial review, and of course the separation of powers. It's a pretty incredible list, right? And here's the thing, if you pull out even one of these pillars, say secularism or the separation of powers, the entire building completely changes shape. This basic structure doctrine acts as a massive protective shield, keeping the original character of the nation fully intact. Now, this untouchable core wasn't just decided overnight. It evolved chronologically through the Supreme Court over literally decades. It all kicked off with the landmark Keshavanand Bharti case judgment back on April 24, 1973. That's what firmly established this whole doctrine. Then you jump to the 1980s Minerva Mills case, where the Supreme Court strongly upheld the basic structure. And fast forward to the 2007 I.R. Coelho case, the court went even further. They stated that laws added to the Constitution's 9th schedule after that pivotal 1973 date are still subject to judicial review. So decade after decade, the Supreme Court has consistently defended this North Star.
Section 2. The 6 Fundamental Rights. The Protective Shield.
All right, let's transition from that massive overarching structure straight down to the specific mechanisms that actually protect you, the everyday citizen. The source notes neatly classify these fundamental rights into 6 active categories. Ready? First up, the right to equality, which is covered in Articles 14 to 18. Second, the right to freedom in Articles 19 through 22. Third, the right against exploitation, found in Articles 23 and 24. Fourth is the right to freedom of religion, Articles 25 to 28. Fifth, cultural and educational rights in Articles 29 and 30. And finally, the absolutely critical right to constitutional remedies in Article 32. That last one is huge, by the way. It's the actual enforcement mechanism. Together, these 6 rights are the living spirit of the text, working directly on behalf of the people.
Moving on to Section 3, Suspending the Rules when the shield drops.
Okay, here's where things get incredibly dramatic. What happens when national survival itself is on the line? Looking at this handwritten branching logic from the source notes, it visually splits the suspension of fundamental rights into 2 very distinct pathways. Over on the left side, we've got Article 358, and on the right side, Article 359. This breakdown is fascinating because it highlights how the Constitution literally plans for its own temporary pausing during emergencies.
So what's the real difference between these 2 pathways? Well, Article 358 deals with the automatic suspension of Article 19, which covers those basic freedoms, but only if a national emergency is declared specifically due to war or external aggression. But then look at Article 359. This gives the president the power, through a separate proclamation, to suspend the enforcement of all fundamental rights, except for those under Articles 20 and 21. Think about that for a second. Even in the absolute darkest, most extreme emergencies, the Constitution draws a hard line. It ensures a baseline of humanity by always protecting the rights regarding conviction of offenses and the protection of life and personal liberty, no matter what.
Section 4. Defining right to equality. The anatomy of Article 14.
Let's zoom back in now, moving from the crazy extremes of national emergencies right down to a profound philosophical concept. Because to truly grasp Article 14, we have to look at its foundation, the rule of law. And this is not some modern invention. The notes point out it was propounded way back by the ancient Greek philosopher Aristotle. He famously stated that law should govern and those in power should be servants of law. Fast forward to modern times, and this idea was popularized by the English scholar Professor Dicey to establish lex superanis, which basically just means the absolute supremacy of the law.
I really want to emphasize this point because it represents a massive, massive historical paradigm shift. For practically all of human history, societies operated under rex lex, which means the king is the law. Whatever the ruler said happened, period. But democracy took that and flipped it entirely on its head to lex rex, meaning the law is the king. It's a fundamental shift in how human societies are actually governed, and it really is the very heartbeat of equality.
And this brilliantly illustrates the nuance baked right into Article 14 itself, which actually borrows from two totally different legal traditions. On one side, you have the UK concept of equality before law. The notes describe this as a negative concept, meaning its whole focus is on the absence of privileges. No one is above the law. But on the flip side is the US concept, equal protection of laws. This is a positive concept. It emphasizes equality among equals, treating likes alike, and ensuring equality under equal circumstances. So Article 14 essentially takes the idea of punishing equally and marries it with the idea of actively protecting equally.
Finally, Section 5. Exceptions to equality rules. The above-the-law paradox.
Now we have to confront the very real friction between absolute theoretical equality and the gritty, pragmatic realities of actually governing a country. So I pose this question directly to you. Is anyone truly treated equally? If we just establish that the law is king and absolutely no one is above it, does the system actually apply to every single person in the exact same way 100% of the time?
Well, surprisingly, no, it doesn't. If you look at the bottom of these notes on equality, there's a very explicit carved-out section labeled Exceptions. The framers of the Constitution were realists. They knew that to make the system function practically in the real world, there simply had to be carefully defined limits to absolute equality. So let's break down exactly who gets these exceptions according to the source material. First up, the President and the governors of states. They are not answerable in a court of law for their administrative decisions, and absolutely no criminal proceedings can be initiated against them during their term of office. Second, you have foreign diplomats and visiting foreign dignitaries. They cannot be punished under the country's criminal law thanks to diplomatic immunity. Now, why do this? Because leaders and diplomats genuinely require a certain override of absolute equality, and I'm not talking about getting out of parking tickets here. It's so they can perform their critical, high-stakes state functions without facing constant legal harassment or triggering an international incident every other Tuesday.
Which brings us to a pretty provocative thought to wrap things up today. If the law is truly king, can a democracy actually survive without exceptions? We've seen today how the Constitution builds this incredible North Star structure. It guarantees fundamental rights, shifts all the power from rulers to laws, but then it deliberately builds in these exceptions just to make reality work. It's this beautiful, almost fragile tension in constitutional design. I really hope this explainer helped decode some of that DNA for you today. Keep questioning the systems around you, keep learning, and we'll see you next time.